Hey doers, it's Alyssa from Legal Doer, and today I want to dive into user-generated content client contracts and the things you need to know so you have a clear handle on what needs to be included in your contract. When you start reaching out to brands and vice versa, eventually you will need to enter into a contract just to finalize everything and make sure everybody's on the same page. Now, contracts are just a part of business. As a business and litigation attorney, I've seen a fair share of contracts, and I wanted to go ahead and provide you as creatives just with some legal insight to really help you guys and also to shift your mindset around contracts and the fear associated with them. Because let's be honest, contracts are actually a great way to protect you as a creative. It defines what you're legally required and not legally required to do. For example, if you send the brand a short form video and they decide that they want it to be reshot in front of a building, you can point to the contract and say, hey, this wasn't part of our agreement. That was not included. It's going to cost you more money. And then you can decide if you want to do it or not, but you won't legally be required to if it's not in the contract. It really alleviates any confusion, miscommunication, or misunderstandings when you have a solid contract. But you have to be proactive, not reactive. Or what I like to say is you got to be a legal doer, not a legal avoider. Before we get into it, go ahead and smash that subscribe button if you're interested in all things UGC, social media marketing, and creator-focused content with a legal twist. So let's begin. What is a UGC client contract? This is a legally binding contract or agreement between UGC Creator on one hand and the brand or agency on the other, which sets out the terms of the working relationship. It's really important to not find some random free template online or pay from other creators, because legal for all is truly legal for none. It gives you a false sense of security because honestly, you don't know what you don't know. So it may not have everything and may be missing things that you don't realize. Oftentimes, general contracts are missing key terms. And with UGC, it would be like ownership or usage rights. So you'll want to make sure that it was drafted specifically for UGC creators. Also, you're going to want to make sure the contract was drafted by an attorney who's knowledgeable about paid content creation and contracts. Be really careful with lawyer-reviewed contract templates because you don't know the lawyer's qualifications. And not all lawyers are created equal. Here are 7 must-haves that you're going to want to include in your UGC contract. The first term we have is scope of work. You have to make sure that the scope of work, which is the kind of services you're providing, are as clear as day to the brand. You want to be as specific as possible. So ask yourself, what exactly are you providing or delivering to the brand? Then include the answer in the agreement. You're going to want to ask yourself questions that might include how many deliverables and for which platform? What is your turnaround time? Does your turnaround time include enough time to get the product, to then use it, to then film it, and then edit it? How are you going to deliver the final content to the brand? You may ask yourself, is the brand required to approve the deliverable before you get paid? Or is the brand required to approve it? How many rounds of re-edits or revisions or reshoots are included in the contract price? How many rounds of revisions or reshoots, yes, different than re-edits, are included? And are there any add-ons? Can they add on to the contract? So the best way to avoid legal headaches and an unhappy client, which is the brand or agency, you got to make sure that there's no misunderstandings about what the brand is actually purchasing from you, the creator. The second legal term you'll want to include is usage rights. And I know a lot of creators have some confusion around what this is. So you'll want to specify how long the brand gets to use your content that you've created, which is also known as the deliverables. But first, what are usage rights? This is a license to use your content. You as the content creator own the intellectual property in the content you create, regardless if the brand is paying you to make it. Now, with usage rights, you are saying to the brand, here, I'm sharing my rights to this content, but for a limited time. And when that time is up, you no longer get to legally use the content I shared with you, and I'm taking it back. You cannot use it without my permission thereafter. You get to set the time frame on their use, and you get to specify how they get to use it. So in this, under usage rights, the term, you're going to want to make sure this includes that it's a license to use your content that is non-transferable and it's revocable, that they cannot share it with somebody else or share it with another brand, and that you can revoke their right to use your content at any time. You're going to want to include the length of that license, the length of their ability to use your content. Because you're giving the brand your content, you'll want to specify, like I said, the time and how. Some UGC creators allow the brands to use their content for 3 or 6 months, while others agree to do it up to a year. Honestly, there's no right or wrong answer here. Ultimately, the choice is yours. I will say though, if you offer the brand to use your content on an unlimited basis, make sure that it's revocable and you include the right to revoke. So say in a couple years, you're like, I don't like it so much. You can write to them and take away that permission that you provided. The third term you're going to want to include is ownership. As I said, as a content creator, you own the intellectual property in the content that you create, even if the brand is paying you. So you're going to want to specify that you are retaining your ownership rights. So your intellectual property rights, they're still yours, and that nothing in the agreement will change that. Actually, the same goes for the brand. You'll want to make sure that the brand gives you a limited license to use the brand's intellectual property, like their trademark, to create the content. You don't want to unknowingly infringe on their intellectual property. But if you are giving up all your ownership rights in the content to the brand, then this is more of a work for hire situation, or when you see terms such as into perpetuity, meaning your name, voice, likeness, and all of that will be associated with this brand forever, and the brand can use your content in any way they like. It's essentially no longer yours. If that's the case, you're going to want to retain a limited right to use it for your own marketing purposes. And you'll want to include language that allows it to use it that way if the brand will actually agree to it. And that way you can use it in your portfolio and all of that without infringing on their rights. Just note that if you are transferring all of your ownership rights to the brand, that means you will not be including usage rights. They won't be included. Either way, make it clear exactly what the brand is getting or not getting in terms of rights when it comes to the content that you provide to them. The fourth legal term that you're going to want to include in your UGC client contract is payment terms. This is an obvious one, but people don't necessarily include everything they're supposed to. So in this clause, you'll want to include how you'll get paid, with a product, with compensation, or both. When will you get paid? Upon delivery of the content or upon them signing the agreement? What's the method of payment? Is it going to be PayPal? Is it going to be Venmo? What's the currency? Are you getting it in US dollars? Do you require a partial compensation or deposit, such as 50% of compensation up front, while the remainder of it is paid upon delivery? What happens if there's a late payment? Will you charge interest? Make sure it's within the legal limits. What happens if the brand cancels it? Do you still get 50%? When it comes to money, it is so important to be very specific and very transparent when it comes to this section. So the fifth legal term that you're going to want to include is term and termination. This is because it's a finite partnership, unless it's a retainer, but you're going to state how long the partnership is for and when or how it can be terminated. Very important. The sixth legal term you'll want to include is independent contractor status. Now, this is important to include a clause that the contract does not form an employee relationship, unless in fact, obviously, if you are an employee of the brand, but typically with UGC creators, that's not the case. Now, certain states have very severe fines and penalties for the misclassification of an employee or independent contractor, but it can't just be a clause. Both parties have to act like a separate business. That is, the brand cannot dictate how, where, or when the UGC creator performs its services. And the contractor is solely responsible for their own taxes, for the withholdings, for the equipment, for their costs. They should not be seeking reimbursement. And that's why it's important to charge your worth, because you are taking on these costs as a separate business owner. The seventh thing you'll want to include is the indemnification clause. Now, what is indemnity? Indemnity is the compensation for damages or losses. It allows one party of the contract to be totally exempt from liability or damages, and it places the burden on the other party. It basically shifts liability away from one party and puts it on the other, who's known as the indemnifying party. the brand will most certainly include indemnification clause in the contract. So you're going to want to make sure that you're not agreeing to take on all the liability and damages should the brand get sued by a third party for any reason, including things that were not your fault. You'll want to include one in your favor too for this reason, but be wary. A general or overly broad mutual indemnification clause also creates issues. This clause has to have the proper language. It's so extremely important to have something specifically tailored to ensure that happens. Make sure to limit the clause to only compensate a party for harm or loss arising in connection with that particular party's actions or failure to act, as opposed to taking on all harm or loss for any reason whatsoever. So those are the 7 legal terms I highly suggest including in your UGC client contract. Obviously, this is not an exhaustive list. There are several more things you're going to want to include in there. I go over all the things that you're going to want to include in my UGC bundle.